Alright, so this is We the People News. This video is without prejudice and or without recourse. Alright, I'm going to go ahead and stand on the UCC 1-308. All rights reserved. Okay, not waiving any of it. Alrighty, sorry. I'm not an attorney. I am not giving legal advice. Anything I say or do is my opinion only. Why? Because I'm not an attorney, y'all. I never look straight forward. I always look around me to be able to protect myself by any means necessary. Alright? There ain't really a whole lot else I can say at this point in time. Let's proceed forward.
Any evidence demonstrating that it can really survive that, aside from Chief Magliano's kind of bare-bones declaration, the Supreme Court held in Playboy Enterprises that those sorts of anecdotes and suppositions are not enough to satisfy strict scrutiny. So if the state can't rely on that, it has to turn to something else. The thing the state tried to turn to here was a robust consensus among jurisdictions, but in fact such a consensus simply does not exist. And that's why the Act fails narrow tailoring, as Judge Cote correctly held.
Has the Supreme Court ever told us to count the states that do something to decide whether something's constitutional?
Well, Your Honor, I think the relevant point here is that in Burson versus Freeman, the Supreme Court said that evidence of a robust consensus can provide support to carry the government's burden under strict scrutiny if the government doesn't have other evidence. But here, the government doesn't have that consensus and it doesn't have the other evidence. So it needs something to survive strict scrutiny because it bears the burden.
Thank you, counsel.
Thank you, counsel.
Mr. Del Pozo, you've got 2 minutes for rebuttal.
Thank you. I'd like to make 4 points on rebuttal. One, this case is like an electioneering case in which the Supreme Court has upheld buffer zones around polling places. Both those laws and this one protect other fundamental rights.
Anything as long as 200 feet?
Well, the Supreme Court said in Burson that if the court concludes that some restricted zone is necessary, then the state need not empirically prove that its chosen zone is perfectly tailored. Mr. Picard has not challenged the 200-foot distance previously in this case. This is the first time, to my knowledge, that he's bringing it up, so the argument is forfeited. But the 200-foot zone would be a sound exercise for legislative.
He can't, by his advocacy or lack of it, limit what we rule in this case. You're here telling us to make a ruling, and you're saying because he didn't say 200 is too big, we can't pay attention to that?
Well, the court can consider or even defaulted arguments. I was simply pointing out that the argument is forfeited, but more to the point, Judge Newman, the Supreme Court said in Burson in upholding a law that we think is fairly analogous to this law in its purpose and effect. Once you conclude that a restricted zone is constitutionally permissible, we're not going to require the state to show that the particular number of feet is perfect. Mr. Picard's main argument is that the number of feet should be 0.
Well, and if we were to consider whether 200 feet is too much, how would we decide that? Wouldn't we have to send it back to the district court and say, decide whether 200 feet is too much, take evidence on whether 200 feet is, why 200 feet? And, have sound engineers come in and testify that 200 feet is where you could definitely hear inside the courthouse what's being said, at least through a loudspeaker, or the visual acuity of people, would they be able to see it from signs from inside the courthouse or whatever? Is that what we'd be in for?
A factual hearing would be prudent for informed fact-finding on that type of question. And that,
but of course, since that argument was not raised by Mr. Picard, there was no opportunity or reason for the state to put in evidence about 200 feet and have suggest that Judge Cote have a hearing of that sort.
That's right, Judge Lynch, and it brings me to my second point and a broader point. Just as this court should not hypothesize about whether 100 or 200 feet is a more appropriate buffer zone, nor should the court hypothesize about cases that may arise in the future with a single protester holding a particular sign or a mob of protesters holding a particular sign. Let those cases arise and the court can adjudicate them as they arise. Our position is that New York's law validly targets or wants to deter outside of state courthouses the kind of thing that happened on the plaza outside of this courthouse in the late 1940s with throngs of people demonstrating, demanding the dismissal of an indictment. And that's not the only important interest that this law serves. The law also protects defendants' fair trial rights. So the protesters could be demanding a conviction. And as the Supreme Court said in Cox against Louisiana, the having a hostile or friendly mob demanding an outcome outside of a courthouse is the very antithesis of due process.
Mr. Poser, I just want to ask a question about the scope of the statute. I thought I heard you say during your principal argument that we're not protected by this. I thought I heard you say during your principal argument that we're not protected by this, that it's a state courthouse and therefore it would only be, you said this protects only state courthouses and therefore it wouldn't be the NYPD so much as state employed court officers who would be enforcing it?
That's right.
But so if there was a howling mob in Foley Square protesting jointly a prosecution in the state courthouse and in the federal courthouse, maybe the state court officers could intervene and that would violate the statute. But if they took down the part about the trial in the state courthouse, they could still be there?
There is a federal statute that
But is there anything in where in this statute does it say that? It says on a public street or sidewalk within a radius of 200 feet of any building established as a courthouse.
It would have to
find
be
somewhere as a state courthouse.
It would have to be. It is most naturally construed to apply to state courthouses. No one has ever argued that it applies to federal courthouses, nor. Well, I won't.
So we are supposed to read their minds of which courthouse is actually what the statute is supposed to cover. I'm glad the judge brought that up.
For what a county prosecutor would do, it would not be a legitimate application of the act.
I see. You're saying that would not be legitimate.
They're allowed to get construed. But we just assume, even if we knew about the law, that it would be all courts.
Application of the act.
Because the act reaches speech or shouting or signage concerning trials being held inside of a state courthouse. So for that reason as well, if the protesters were protesting something in the federal courthouse.
Does it say that? It says such courthouse. So it's all a question of whether established as a courthouse should be construed to reach only state courthouses.
It is also within the New York State penal law, which presumptively applies to
I get it.
state facilities. I get in the most capacious textual reading, then perhaps somebody could make that argument, but we don't think that the statute fairly applies to this
Got
courthouse.
it. Thank you.
I will say one last thing.
Briefly, counsel.
Thank you.
No, you can wrap up briefly. That's what I said.
Thank you, Judge Park. The statute, even as Judge Cote acknowledged, there's several indicia of narrow tailoring. The content distinction is actually a virtue in this case. It does trigger strict scrutiny, but it also makes the prohibition fit the state's interest like a glove. It is not over-inclusive. It doesn't bar one-on-one conversations, nor does it bar general political protests outside of courthouses, at least. This statute doesn't. Nor is it under-inclusive, not reaching other types of speech that would similarly denigrate the judicial process. That was the flaw in the statute in Reed against Gilbert, for example. The statute was riddled with so many exemptions it placed analogous billboards on different footing. There's no risk of that happening here, and the statute is not duplicative. Contrary to what Judge Cote held, there is no other law that, at least I know of, or that we've been able to find that reaches broad-based, indiscriminate, trial-related speech within 200 feet outside of a state courthouse that doesn't target any particular juror or witness. So this statute serves a unique and distinct function, has presumptively legitimate applications under binding Supreme Court case law. We think that the statute should be, or that the injunction should be limited for that reason to an as-applied injunction, or alternatively, the question of its scope should be certified to the New York Court of Appeals.
Thank you, counsel.
All right. Subscribe to the Junkyard News. All right. In common law, y'all, laws are supposed to be clear and defined for anyone to read it and understand it. We got these statutes and codes that is so broad that we're supposed to mind read what these lawmakers are intentions are. But their intentions is the trickery of words to make you believe this, so you're entrapped into this. And somehow or another, you must get an attorney to go ahead and fight the case. It's all designed because most representatives of any states and federal are some type of attorneys. And you got the mute few it's not. But by large, they're attorneys, and even the ones that are not attorneys, they have attorneys if they have legal questions. Well, why? Because technically the law is supposed to be easy to understand and defined for anybody to understand it. Because poor people may not be able to afford an attorney. And they may have to, what you guys call, represent themselves. But how can they represent themselves properly if there's not a clear and concise of the law? And then how do you know that you're not actually getting screwed over of the words they are using in there? We all drive every day around our states and all that, y'all. And we assume by hearsay what laws are. But we never ask questions. And then when you do ask any government officials questions, they say, well, you must speak to our attorney. Why? They're the ones working there. Why are we asking attorneys what their job is? It is their job. How come they don't know their job? Right? And police officers is well trained and well reversed in the Fifth Amendment, and they use it all the time. The reason why you don't hear officers apologizing, because it's admitting wrongdoing. The attorneys stress that to officers never to apologize. You get some every now and then may apologize, but by large, they are stressed not to apologize because that would be some type of form of admission of guilt. So when you expect any officers or judges or clerks or anything to apologize, they will never apologize, except very few, because that'd be admit to guilt, and it's going to be harder to win the lawsuit that you would bring upon them. So even for y'all out there, never apologize. And always stand on the Fifth Amendment. Always. If they're allowed to do it, then we the people are allowed to do it. Alright. This is We the People News. Till next time, bye y'all.